everybody, and welcome to Patriots Law Group Live. This is all military strategies for military divorce. If you are experiencing a divorce out there and you are a service person on active duty or a veteran or even a military spouse, well, you are in the right place. We are here every other Wednesday, twice a month. And we bring you different topics to help you navigate this very difficult situation. And today is no exception. We have something off the beaten path a little bit today. It's very specific to one state. We're going to talk about protecting your parental rights. We're going to give you 5 insights today into the Virginia Military Parent Equal Protection Act. So like I said, it's very specific to a state, but I think you're going to pick up some really good strategies, insights, and resources today. And that's what this show is all about. And of course, we have 2 incredible lawyers with us from the Patriots Law Group. We have Mike Lyons and Pat Hughes. And welcome, Mike.
Thank you. Thank you, Maureen.
And welcome, Pat.
Happy New Year.
Happy New Year to both of you. And the show is certainly never going to be great without the 2 of you. So I know, Pat, you're going to be running the show on this one today, on this particular topic, coming more from the state of Virginia. And so I'm going to start with you. We've got 5 insights on this particular topic. So would you like to kick it off with number 1?
Yeah, well, I guess to preface it, we're focusing on Virginia. I'm licensed in Virginia. Mike's not. So he's going to bring some perspective from what jurisdictions he is licensed in, primarily Maryland. That I'd like to think that although Virginia is codified in a particular way, some very helpful things here for those who are in the military, that the courts in other jurisdictions might even be willing to borrow the concept that Virginia's instilled here, but or already does employ it in some fashion, and so this will be helpful more beyond Virginia, I think, in some ways while we talk through things. But as it relates to, I guess the first topic that we were planning on talking about is, this is really about child custody that we're talking about and the impacts that can happen when someone's deployed. So military members are deployed for varying lengths. I think more commonly it's about a 6-month deployment that people are imposed by their service. It used to be much longer for some of the other services outside of the Air Force. We were, I think, primarily a 6-month deployment length that Mike and I had to know, and Mike in fact dealt with himself on his way to Afghanistan, right? It
was a good time though.
Sure. Well, you got a Bronze Star out of it, right? So and well deserved, of course, well deserved. But these are opportunities that the non-military spouse might try to take advantage of, or that there are difficulties that are brought upon the service member because their employer, the military, has taken them to a far-off land, and now what's going to happen with the child custody arrangement is a big, an important problem that can arise for a military member when they're deployed if they don't take the actions that can be taken through in Virginia under the Military Parent Equal Protection Act. And so one of the topics, the first topic that we wanted to talk about, was that there not be permitted any permanent custody modifications sought and granted by the court on behalf of the non-military spouse solely because that person deployed, the military spouse deployed. And so the Military Parent Equal Protection Act ensures that a military parent's deployment can't be the sole reason for permanent modification of a child custody arrangement. That's what that provision seeks to do. And it doesn't mean that there can't be other reasons that could be thrown in there in an attempt by someone, but But if it's the sole reason, then that's not going to fly under the system that Virginia, it's not supposed to fly under the system that Virginia has developed. So, I mean, I don't know, Mike, what are your thoughts as it relates to that for Maryland, for example?
Yeah. In Maryland, we confront all those same sorts of things. People will say, oh, a 6-month, 9-month, 12-month deployment. The non-deploying spouse then suddenly has 100% of the custody. And over time, stability factors start to point to, maybe not disrupting the situation that's been established during the deployment. Now that a child's been in one school for a year or been in one parent's house for a year, the deploying service member coming back, but there's a recognition, rightly so, that's not appropriate. The military parents can't be serving their nation and coming home to a burden like that. And we know there's military children all over the place who lived that, life for 20, 25, 30 years, because of their parents' military service. And so both in Maryland and in Virginia, a deployment can't be used, as you said, as a basis for modifying custody on a permanent basis.
Right.
And the one nice thing, and really to point out here, that I, as an attorney, if I'm handling this case in Maryland, although I don't have this same statute, I will be pointing, as Pat mentioned, to statutes across the nation and to public policy, because there are other laws that point to this idea that service shouldn't be a disqualifier. And to say, hey, judge, holding aside the deployment, was there material change in circumstances? And if there was it something that the non-deploying spouse should have been considering the fact that the service member was coming home? So they said, oh, I moved. Well, you moved knowing that this was a temporary deployment and you're making a permanent change. That should be held against the non-deploying spouse. Most courts would agree with that. So yeah, I do see this in the Maryland side, and I think this is a really strong positive thing. A number of years ago, courts would say I have to just analyze it for what it is, and the service members been deployed for 5 months, and the non-deploying parent is coming in saying they need to enroll these children in school, and I'm just going to set a new custody order, and we'll deal with it when the person returns. But all of those factors of stability came crashing down on the deploying service member, and it wasn't fair. These laws are relatively new and work to correct that.
Yeah, and the key terminology that this topic was focused on is a permanent modification, right? Permanent being the key term. Topic 2 is temporary modifications. It's not to say that because a service member is deployed that there shouldn't be some sort of change to what the norm was. I mean, someone is being taken away from their kids and the environment that those kids were, living under for many months. The non-military, parent is likely to have to take on some additional responsibilities, but the key in this topic is that those changes are solely for and limited to the deployment's duration, right? So as if when the person returns, it's back to what it once was. So the Military Protection Act, Parent Protection Act here prevents the changes from extending beyond the deployment's duration. And so back to the point that Mike was making, non-military parents may try to take advantage of the circumstances, but under this codification, the moment the person returns, whatever used to be the status quo should be returned to that situation. And so the courts have the ability to enforce that under this particular provision. Mike, anything to add on that
No, I agree. I mean, just the longer custody is changed, the more the courts are struggling with, the stability factors and disrupting the children. So, so this is a very positive point of this law in Virginia for sure.
Yeah. And Maureen, you can imagine also that there's a lot more to the family tree than just the person who's deployed. So topic 3 is talking about the ability for visitation rights to be extended to the deployed members' parents or siblings, uncles and aunts of the child, and that visitation rights of family members of the deployed member be extended to them. It would be very easy for people who didn't get along, and that's why they led to a divorce, that the non-military spouse might not want the children to be visiting with grandpa and grandma of the deployed military spouse, for example, right? And so, as unfortunate as that circumstance may be, the fortunate thing is that the law permits the military member to get delegation of visitation rights to his or her family members. Now, one of the important things, though, is you kind of have to plan for this, right? It's not something that you can just say, hey, I want this to happen. I'm now deployed, and like, how are you going to get to the court to say, hey, we need this to happen?
Like Oprah Winfrey, you get a child, and you get a child, and you get a. Okay.
So that's something that you would have to take efforts in advance to do before you deploy, so that there's something enforceable and an order exists to permit that to happen. And that's a key, right? And unfortunately, I mean, obviously, as you're getting ready to deploy, right, there's pre-deployment training. Mike, you went to Fort Dix, I think, for pre-deployment training. So that's like a month in advance of your deployment. I mean, you typically will get advance notice of when you're going to be deployed, and this just adds to the checklist of things that you would want to add to making sure you check the box on if you're wanting to have this happen. Certainly, it's not a convenient thing to do, but it's important, particularly when there's a lot of strife between the now divorced couple and there's a child custody dispute that's ongoing. That you want to make sure that you're preserving your rights to the extent that you can, the full extent that you can, because if you give an inch, the other side may take a mile. Right. And so you need to make sure that you're taking the efforts needed to show to the court that it's still in the child's best interest that you remain in their life as much as possible. And this is a way, like, not just you, but your family. And so, you need to make sure that you've planned and taken the efforts with the court in advance, using this provision as codified in that act to allow the family members to be able to see the child or children during the time that the person's deployed.
Now, I have a question. We're talking about Virginia right now. So I'm gathering that every single state has their own Equal Protection Act. And am I gathering that everybody's got their own? Because we've got people tuning in from all over. So if somebody's saying, well, I'm not from Virginia now, do I have to go back and say I'm in North Dakota, or I'm in Texas, I'm in Massachusetts? Everybody's got their own separate one. So now I've got to look into this, because this may not, or it may apply, but everybody's got their own.
Right. So unlike so many other areas that we've been talking about in this series, this is not a product of federal law. So that's why this is specific to Virginia. Each state has or does not have specialized laws to deal with service members and how it should be dealt with the deployments. The default position, as I mentioned, sort of, 10, 15 years ago was, hey, it's just a child custody case, and the best interest of the children is the only thing that we're concerned about. And these statutes have been started have started to occur, particularly because deployments in the post 9/11 era tended to be a steady state of deployments. People were frequently being deployed, their units, their individuals. They were 6 months in country, 9 months out of country, 6 months back in country. And it was really starting to be, a burden for recruitment in the services, so some pressure from the federal government. But the gist of it is Virginia has a very good statute here, I think a better one than Maryland's laws provide for. Maryland has some of these provisions, not all of these provisions. There's no delegation of visitation in Maryland. There is a limitation of any modification that occurs when somebody's under orders for deployment to only being temporary, to lasting only as long as the deployment, and then expedient review upon return. So the answer is it is an individualized research project for every state that you're in. And somebody that deals with family law, that focuses on military clientele, are likely in the best position to help if you have some extra rights as a military parent or not.
Okay. That makes sense.
I wanted to mention too, this is just a real tactical move or strategic if you're a practitioner. One of the benefits of the delegation authority, and I wish we had it here in Maryland, is what it does is it keeps a space, right? It sort of acts as a shelter for the regular custody schedule. Now, the courts don't have to say, let's say it's week on, week off. The courts don't have to say week on with let's in this case say the father's the non-deploying parent, week on with the non-deploying father, and then the next week with grandmother, right? I mean, that's nuts. It doesn't necessarily say that. The court can say, okay, I'm going to do every other weekend with the grandmother, whatever makes sense for the children. But having this ability or coming up with something that could work, maybe it's the summer with the grandparents. What it does is it sort of, you don't default into that one parent saying, I've been the only parent for 100% of the time for the last 365 days. You're now taking away time into, this time has been with grandmother. Now it's back with mother, and it's sort of an even exchange. And that tends to be helpful in these custody cases. Not appropriate in all cases, but when it works and it is appropriate, it's helpful from an argument standpoint.
I think Virginia has a very large military presence, especially down in Norfolk and Northern Virginia with the Pentagon and all. And so Virginia has a desire to want to support its military in a much larger way than many other states may, because it's just not as large of a presence in some other states. And that may be part of a driving force for why Virginia decided to codify things the way that they did and other states haven't. But it's not a one size fits all across the country.
I think the Navy too we're going to get down here, I think topic 5, and it talks about communicate, a non-deploying parent cannot or must accommodate the leave and the ability to communicate of the deploying parent. Well, the Navy's out on ships and submarines where their communications give away their locations and therefore create a vulnerability. And so there's only these limited periods of time when those service members can talk or have leave because the ship, everybody's on it to keep it running until it's at port. Some of the other branches, the Air Force, the Army, the Marines, it's a little bit different. It's sort of you're deployed and you're not deployed rather than a steady state, out to sea sort of thing. So just want to
I'm willing to flex. We can talk about topic 5 in advance of topic 4 if you'd like.
All right. Well, let's flex. I say flexibility is the key to air power, and we're Air Force. So
that's right.
You're jumping around.
Well, I mean, so it's expressly codified that accommodating someone's leave schedules and facilitating communications must be permitted by the non-military spouse to make those arrangements for when a military spouse has the ability to try to communicate with the child while they're deployed. I mean, based on the lengths of deployments now, there's not often a break during the middle of it, like a R&R, rest and relaxation break, where they get to return. But if there was, then that would be a prime example of when there would need to be an accommodation made, because that's not always set in stone as to exactly when it's going to happen. And then all of a sudden, it does happen that they get notice that, hey, we're going to give you a couple weeks back to recharge before you get brought back into the fight. And so it would be at that point that obviously the military, deployed member, the parent would want to see his or her children. And so even in the situation that if it became necessary, an emergency order could be sought, an emergency hearing could be pursued to make that happen. If the non-military, I may have kept saying spouse, but they're not spouse anymore. If I did say spouse, they're, the divorced parent, non-military parent, was preventing the ability to gain access, then that would be something that could be handled in an emergency fashion, which everyone thinks things are emergencies. In family law in particular, it's something that we encounter a fair bit, but unfortunately the law and the courts don't view it in the same way as parents do. But this happens to be one of those circumstances where it could be handled in that short of a fashion, because it would be irreparable after the 2 weeks have transpired and they have to return if they didn't get the opportunity. And so that's not something that other courts would necessarily consider an emergency. But now under this accommodation in the Military Protection Act, Parent Protection Act for Virginia, it could be something that they could pursue. And Mike, I mean, from the perspective of Maryland, for example, is that something that you think would be handled in an emergency fashion?
It would have to be definitely context specific. How long, are you going in a hostile fire environment? How long will you be gone until you return? Yeah. If it's you're going out to sea for 4 weeks, maybe not. But to that point, the pieces here from a practitioner's perspective is don't show up on Saturday, the first day of leave, and say, I'm here to pick up the kids. I'm off for a week.
Right.
The courts are going to be a lot less inclined, or at least a lot more receptive to maybe there's some other things that we need to balance. So you want to start that, a couple of weeks ahead of time. Hey, here are my leave dates. Here's what I want to do. Hopefully you get a commitment to yes, then that's going to work. If you need to go to the courts and say, now they're suddenly irrationally blocking this, we had an answer of yes, I would have come to you sooner, but or if you get an answer of no, getting with an attorney to start developing that, case. The other thing is, if it is blocked, say communication. When I was deployed, of course, we had Skype. I'm sure there's other technology now, but back then Skype. Yeah. If you had a child and you're it's agreed or whatever it is that you're supposed to speak with the child at a particular time and it doesn't happen, document it. Send an email to the other side that says, hey, we agreed today at 7. I was on till 7:15, and then I had to give up my Skype station, and we didn't get a chance to talk. Let's coordinate for tomorrow. After that's happened 4 or 5 times, you're starting to build a case. One mistake I see a lot of clients start to make, and this happens in a deployed environment or not, is they say, well, I know they're not going to pick up the phone. They haven't picked it up the last 5 times. So I stop calling. It seems silly to do the same thing and expect a different result. But you should do the same thing and document it the same way, because the result at that point isn't they're going to pick up the phone. The result at that point is you're going to get back from the deployment. Because this is going to be harder to an emergency hearing if it's communication, but you're going to get back from the deployment. And it's at that point that you can get things hammered down for the next hearing, or excuse me, for any future deployment, where it is, if you don't do X, then you maybe lose custody. There's some sort of fine. There's something that protects you. Maybe it's a change of custody altogether. But yeah, this law gives that much more teeth. It isn't just we have to agree to speak. This law says that they shall accommodate. If you build that record, they're not, then you have a remedy by coming back into court. So I think this is a really positive thing. Maureen, to your point, this provision is something that you see a little more universal across the states. And so it's just the delegation and some other aspects that are pretty unique for Virginia.
I do want to welcome Stacy Blackburn. She's been tuning in from Facebook and has been listening to both Mike and Pat. So welcome, Stacy. She's been making a few comments as you've been talking. So yes, they do. Oh. And so as you've been saying stuff, I'm not quite sure what she's agreeing with you on, because you kept talking as she was going.
Well, she should be agreeing with everything that I say.
She's like, hi, guys.
Because
so there must have been something in there that she agreed on something. But
she was my defense paralegal. She works for me as my paralegal.
Okay. So she knows you. All right. So Stacy, welcome. If you know them, then they're pretty bright here. So you jumped to 5. Does that mean we missed 4?
We'll
or have you
backtrack.
been kind of weaving it in?
Yeah. Well, Mike had mentioned the term expedient review upon return. If you needed to challenge things or make things restored to the status quo before the deployment occurred. And in Virginia, they've actually instilled a 30-day requirement for a hearing if upon action within 30 days that a hearing occurred to deal with the issue. That's a blessing to have that. If you know how fast-paced the court system is, and when I use the word fast-paced, maybe I should be using a different term, because it's as fast as molasses. And so 30 days is a very quick turn for someone to have a hearing, absent it being an emergency, which is of the rarest of cases that you're able to satisfy that criteria to get into a hearing in an emergency basis. And so for a non-emergency hearing to occur within 30 days, that's a great thing. And that's a requirement. If you invoke this provision within the act. And so 30 days, you get the hearing, the court can then take action to restore what once was, or to deal with issues if there was a intentional move on the part of the non-military parent to prevent access or not adhere to orders that were in place, and to potentially do something that might be in the favor of the deployed member as they've returned because of the misconduct, we'll say, of the non-military parent. So those are options that can be brought to the court and be heard within 30 days upon returning from a deployment. Once the motion is filed, the hearing, then that starts the 30-day clock. So it's not, I'm now back boots on the ground, and within 30 days that the hearing will occur, unless a motion is filed on that very day, which you could do if you've hired an attorney in advance and said, I got this problem and I know it's there, either expressly or I've read the tea leaves that my non-military parent, co-parent, former spouse is not going to make things easy for me, and I'm going to need to take court action. You can anticipate that and get it going, and within 30 days get that hearing.
Yeah, different states, be mindful of different states have different timelines for when you can file for this expedited review and hearing. So every state, you should check that out. Here in Maryland, you have to do it as soon as you get back from deployment, which might be, I'll get to that in 30 days, because I'm signing a new lease, I'm getting my stuff out of storage, whatever it is. But unfortunately, or maybe reasonably, you need to prioritize this at the top, or you may lose the expedited review, or certainly if there's any sort of argument over what should happen, then coming back to court and saying, I want to resume immediately is going to present differently than coming back 4-6 months later and say, okay, I want to get back into my custody arrangement because it didn't seem to be important to you then. And the court's going to treat it as not so important for you now. And so use this provision to your advantage. It really can be strong if you're coming marching into court right out of the gate and saying, but for military service, I would have been here, or I would have my children on my schedule today. Military service prevented that. I'm starting it again today.
Yeah.
Wow. As
We did
usual. As usual.
We filled the half hour. We did it.
You always fill the half hour.
That's too easy to do.
It's jam-packed with information, and that's what this is for. I mean, this is resources, insights, tips. I mean, we fill 30 minutes of just unbelievable information. And you know, that's why I say, for people who are out there, if you are navigating a military divorce, if you are a veteran, you're a military spouse, you are active service person, please, this is the place to be. We're here every second and fourth Wednesday of the month. This live stream brings these types of topics. There's a different one every time we appear. This is Patriots Law Group Live. These are legal strategies for military divorce. And we've got two experts here. Mike, I know that you like to put a little disclaimer at the end of every show. So I do ask you to do that real quick before we close it out. So go ahead and give the 10 seconds here.
Yeah, exactly. As we've mentioned in other of these, every case sort of lives and dies on its own set of facts, both before the court and what's going to make sense in everybody's life and their children's lives. And so this information we're providing is to sort of allow for military parents and their counsels to issue spot, but we highly recommend that they engage with a military focused attorney, or any attorney for that matter, to find out what exactly they should do in their case. Some of this information and advice may not be appropriate in the context of one of the listeners' cases. We can't know that or see that without knowing their full set of facts. So please seek out legal counsel, free legal assistance on base if you're eligible for that. Otherwise, counsel in your local area. Thank you, Maureen.
And of course, if you want to have an attorney like Mike or Pat, you can go to patriotslawgroup.com. There are also amazing resources there, including several of our episodes from the past. So if you like what you have watched here, there are plenty of episodes from the past. So we would love for you to see us in a couple of weeks. We will be back with another amazing episode. Thank you for tuning in today, and we will see you soon. We are out of here. We have gone overtime today.
Say hi to Jackson for me, Stacy. Take care.
Bye, Stacy. Thanks for tuning in. All right. Goodbye, everybody. See you soon.
Take care.
Were they?